Hello friends, this is Dr. Shashi Agarwal. I welcome you all. Today our subject is business law and the chapter is offer and acceptance and the topic is essentials of valid acceptance. In the last video we have covered the what are the essentials of valid offer. If you find my video useful, please do like it, share it and also subscribe my channel Shashi Agarwal. So this is my app, Edusum app, which you could download from Google Play Store. This app provides free study material and free mock test to the student of commerce, economics and management. Even this app has structure courses also. So business law is also available in the form of structure course. So first of all, we will understand what is the meaning of acceptance. When a proposal is made to the party, the next important thing is to accept that proposal. When the offer is accepted by the person to whom the offer is made, then we say the acceptance of the proposal convert into the promise, or we could say the agreement. Like here in this case, A makes an offer to B, I want to sell my bike for rupees 20,000. B said, yes, I'm ready to buy your bike for rupees 20,000. A made a proposal to the B and B accept that proposal. Then it becomes the agreement, or we could say then it becomes the promise. When the person to whom the offer is made, when he gives his consent, then it means that he has accepted the proposal. Section 2b says an accepted proposal is called a promise or an agreement. When the proposal is accepted, then it becomes a promise. Once offer is accepted, then it becomes a promise. Then offer cannot be revoked or withdrawn. When offer is accepted, then we cannot withdraw or cancel our offer. After acceptance, each party becomes legally bound by the promise which is made by him through the medium of offer and the acceptance of it. In this scenario, like A made an offer to sell my bike for rupees 20,000, B accepted that proposal, then here the responsibility of A is to hand over the bike to the B and B's responsibility is to pay him 20,000. Acceptance may be expressed when it is made by spoken words or written. When we, like A said, I want to sell my bike for rupees 20,000. By speaking, B said, yes, I am ready to buy your bike for rupees 20,000. So it is through spoken words. And when the offer is accepted by writing the acceptance, then we say acceptance is expressed. Implied when the acceptance is gathered from the conduct or the behavior. A bus is going for a Bathinda and we board that bus, then we have to make the payment of fare because we have our behavior has accepted our conduct has accepted the offer of that bus. So that is gathered from our conduct or behavior. So this is the implied acceptance. Who can accept? When an offer is made to a specific person, then the offer is accepted by that person. Like in the case of Bolton versus Jones. D was having account with a firm, but now firm was taken over by B. D sent a offer to the old firm, but it was accepted by the B and the goods sent to D. B sued D for the price, but the court held there was no contract because the offer was made to the old firm, not to the B. So the offer, when it is made to a specific person, then it should be accepted by that specific person. But when it is made to the world at large, for example, by giving advertisement in the newspaper, in such a case, only person or person with the notice of the offer can come forward and accept the offer. Like in the case of Carlyle versus Carbolic Smoke Ball, company has given the advertisement, the whosoever uses our smoke balls as per the instruction, if he contract influenza, we will give a certain amount of reward. Carlyle fulfilled that terms and conditions. In spite of that, she had influenza. Then the company has to make a payment to the Carlyle. When an offer is made to the public, so anyone from the public can, by complying the terms and condition, accept the proposal. Acceptance must be, these are the essential of valid acceptance. Acceptance must be absolute and without any condition. When we attach some condition, then it is not a valid acceptance. Acceptance must be unconditional. It means it should be in absolute terms. It should not have any condition attached with it. The acceptor must comply with the terms of the offer. Like in the case of leading case Neil versus Merritt, an offer to sell land at $280 and accepted the offer, but he attached the condition. He enclosed $30 and rest in monthly installment. So it is not a valid acceptance because acceptance was conditional. I will make the payment in installment. Acceptance must be absolute. In the case of Hyde versus Wrench, A offered to sell his firm to B for £1,000, but B said he would buy for £950. So he is making a counter offer. Later on, he agreed to purchase for £1,000, but A refused to sell the farm. B sued A for specific performance. The court dismissed his suit by holding there was no valid acceptance, so there was no contract. Acceptance must be communicated to the offerer. When a proposal is made to the offeree and offeree accepted, then it should be communicated to the offerer. If it is not communicated, then it is not a valid acceptance. It must be communicated to the offerer himself. When a person accepts an offer but fails to post the letter of acceptance, so it is not a valid acceptance. In the case of Powell versus Lee, the board of manager of a school resolved to appoint A as the headmaster. One of the board of manager informed A about that he is appointed as a headmaster, but later on some other person was kept. It was held no formal communication of the appointment, so it is not a valid acceptance. He cannot file a case because the acceptance was not communicated to him. In the case of Feldhaus versus Bindley, F offered to his nephew a house at £1.30 and said, "If I hear no more, the horse is mine." But nephew did not reply. He told his auctioneer not to sell the horse, but auctioneer sold it by mistake. Then F sued his nephew, but the court held mental acceptance or uncommunicated assent does not result in a contract. Acceptance must be made within a reasonable time. Acceptance must be made within a time allowed by the offerer. If the offerer has given some specified time, then the acceptance should be made in that permitted time. If the time lapses, then we cannot make acceptance. If no time is specified, it must be made within a reasonable time. So what is reasonable time? It depends upon the circumstances of the case. Ramsay Gate Victoria Hotel Company versus Montefiore. A person applied for a share in a company in June, but he got allotted, but the allotment was made in November, so it was not a reasonable time period. So it was not a valid acceptance. And the acceptance must be according to the mode prescribed, has to be made in the manner which is described or indicated by the offerer. In case of Surendranath versus Kedarnath, offer was made to B by A to sell his house for ₹1,000. If you are interested, write to F at his address. Instead, B sent his agent to meet F personally. So held there was no violation. So it is a valid acceptance. The acceptor must be aware of the proposal at the time of offer. If he is not aware, then it is not a valid acceptance. Like in the case of Lalman Shukla versus Gauridat, G's nephew has been missing from his house. He sent his servant L to trace his missing nephew. When the servant left, G announced that anybody who discovered his nephew, he would be given reward of ₹500. The servant discovered the missing boy, but he was not having the knowledge of the reward. So he cannot claim the reward because he was not aware of the offer. Acceptance must be given before the offer of lapse or before the offer is revoked. In the case of Union of India versus Gopal Chandra, a prospective resignation to quit post as an offer, but it can be withdrawn or revoked when it is before acceptance by the competent authority. If the resignation is accepted by the competent authority, then it cannot be withdrawn. It could be withdrawn before the acceptance by the competent authority. Acceptance cannot be implied from the silence. No contract is formed if the offer remains silent or does nothing to show that he has accepted the offer. A told B, I offer you my car for rupees 50,000. If you do not reply in 10 days' time, I will assume that you have accepted the offer. B kept silent and he did nothing to show that he had accepted the offer. So, held there was no contract because it is not a valid acceptance. So, effect of silence in the case of Brogdon versus Metropolitan, draft agreement for the supply of the coil was sent to the manager of a railway company for acceptance. The manager wrote on the agreement accepted, but he never posted, so it is not a valid acceptance because acceptance is not communicated. In certain circumstances, the effect of silence on the acceptance may be indicative of the consent to the proposal, where the offering have a reasonable opportunity to reject the offered goods, but he takes the benefit of them. It will amount to the acceptance. In the case of Kashi Prasad versus Sajadi Begum, landlord sent the notice, the enhancement of the rent, but the tenant continued to occupy the premises. So it means his silence has given that he has accepted, where because of previous dealing between the offeree has given the proposer reason to understand that the silence was intended by the offeree as manifestation of assent, and the offerer does so and understand. In that case, that is a valid acceptance. Acceptance is subject to contract, where an offer or acceptance is subject to approval by a certain person. So contract will arise when that consent is given by that specified person, and there will be no contract till the formal consent of such person has been obtained.